Can you hear me? Okay, good. Sorry about a little bit of a wait. Anyway, we're gonna, without further ado, just start on. And about last lecture, I had posted. Good morning, Cindy. I have posted a feedback note on Facebook, but I did not get any feedback from any students. That's why I decided to what you gained from the previous lecture where Mr. Klopfenstein was speaking to you, and what areas were the most important ones at this point that you would want to cover again, or what areas were that you guys had a good grip on. So think about it again, and if you guys have anything else that you would like to talk about in defenses, we will go over it. But for now, I'm going to put it on the back burner, and once we are finished with the course completely, we just have a few more things left, then we will move on to the defenses again if there's anything that needs to be addressed. Otherwise, we will definitely going to cover it in the review for sure. Other than that, I have prepared my notes for the topic of defense for you guys, and I will be uploading it shortly. Tomorrow, it's a public holiday in the United States, so if there's a little bit of a delay, don't worry about it. You will get it early next week for sure. So today, what we're going to cover, as I posted for you guys for the assigned reading, was non-fatal offenses against the person. And it is not that hard or complicated of a topic. It's fairly simple. The things that go from back and forth from one to the other are fairly simple and similar. There may be a little bit of minute differences that differentiate one from the other. 5 major ones that your guide has covered, we are going to cover those, although there are more than that. And we'll go from there. And again, as usual, I have some helpful graphic charts for you guys that you can look at and save it for your reference. And you don't need to, again, copy or screenshot anything from the slide. I will provide you these graphs and tables with the notes. So we are going to move on now, unless anyone has any questions. Okay. All right. What is violence? Violence is causing physical harm. There are the offenses are described between fatal and non-fatal offenses. Fatal offenses, we have covered some of those, for example, murder, rape, sexual offenses, grievous bodily harm, and all those things are the fatal offenses. But the non-fatal offenses are the ones that are not as serious, although they are offenses, and they cause, some of them do cause harm to the body and or mind, and some of them also need prosecution need to prove beyond a reasonable doubt that this has happened. There is a causation involved in some of those, but these are fairly lightweight crimes, as I call them, and your guide and also your course divide them into 2 parts. There's the violence crimes and the crimes against autonomy. What is the difference? There's a very little difference in it, as you can see on the slide. Now, the violence your guide described as the criminal wrongdoing for such crimes is the causing of physical harm to another. Proof of physical harm is therefore an essential ingredient of these offenses, and equally importantly, the offenses may be committed irrespective of victim's consent. Okay, so like you said, although there may be consent, but the crimes may still be committed, some of those. The state takes a view that causing people physical harm is inherently wrong, and with some obvious exceptions, such as surgery, the consent of victims does not make it right. You cannot say that, yeah, she told me that, okay, I can go on and punch her, but there's a little difference that, okay, she may have consented you to play or, you know, have a little bit of a lightweight fight, but not break her nose or make her bleed. Okay, so those are the violence crimes. They cause physical harm. They mean they need proof of physical harm. Okay, consent is often irrelevant in those, except the surgery. Why is the surgery exception? Because sometimes in medical interventions, you are not in a position to consent, but it's really important and vital to save that person's life. And sometimes doctors or hospitals have to take these kind of measures where you can't wait for the consent, or you cannot just, you know, wait for an unconscious person to come back to his senses and tell you, okay, fine, I'm okay with surgery. No, that's most often in emergency cases, this is not the case. And since doctors are under the duty to act, being doctors, they have a duty to, you know, be a good doctor and provide medical help to the person who is injured or who is in need of help. So yeah, here, I mean, it's not. This is not the case where the consent is irrelevant. This is the case where the consent would not work. I mean, he will not say that I didn't ask him to, you know, stitch my head when I was going to bleed to death or something like that. Yeah, I mean, these kind of things, they happen, and we'll see how. And always remember that most often what we read are the general rules. There are exceptions exist. Always, always, always you will find, almost always you will find at least one exception to one or more general rules, okay? Now, what are crimes against autonomy? Your guide describes it as criminal wrongdoing for such crimes is the undesired interference with victims' autonomy or freedom of action. Okay, it's like a freedom. I want to do what I want to do. Don't stop me or don't push me to do something else. Those kind of things are your autonomy, your control over your boundaries, your body, your, you know, your desire to go out, have a drink, or go out to a nightclub, or watch a movie, or just sit home on the couch all day long and watch TV. Those things are considered your right, your autonomous, okay, and you have a complete control over it. Interference to that interference to that autonomy is called, would be considered crimes against autonomy, okay, right. Proof of physical harm is not an essence of these kind of offenses. Rather, the victim's absence of consent is. So yeah, I mean, you can use it as a defense that she didn't have my consent, or he did not have my consent, and yet he still go on and did it. For example, there was a case in the United States that I read. I don't remember most often I don't remember the name of the cases for United States law. I remember the facts because here we don't have to provide the names and the dates of the cases, unlike English law where you have to really remember the cases with the facts. And sometimes if there is a high-profile case, you will remember the name. Sometimes it slips through my mind, but I do like to relate to it, use those as an example because they're real cases and real-life situations that happen. So anyways, there was a couple who was on a date, and they were, after food, they were in the house in one of their places, and they were making out, and the boy put his hand behind the girl's neck, and he held it a little too tightly, and it snapped. There was a click, and she kind of had a little bit of fracture in her neck. What he said was in the court that she had a consent, but the court said, and was our defense, that I had a consent for him to make out with me, to kiss me, not break my neck. So these kind of little bit of situations that are very close to each other, where you have to really think about that, well, did she have a consent or not? So you have to really think that what exactly is the issue. If you have a situation here in your exam, you have exam problem, you have to really decide first what exactly is the issue. Was the issue that they were gonna, why are they making out? Or was that an issue that he committed battery and he broke her neck, okay? So as soon as you put down your issue, you realize what your real issue is, and you can go on and move on to the rule and the application, so on and so forth. Okay, that was the general overview. Okay, so I made this chart for you. It's an upside down triangle, as you can see, and it goes up from severity. Your guide, in your guide, if you have read, you start from wrongdoing or causing grievous bodily harm with intent and move towards assault. Your guide has the most severe ones first. Okay, we are gonna here start with the least severe ones. Why do I call it least severe ones? Because there's a difference in the harm, there's a severity difference in the sentence, and some mechanism of proving the wrong. Okay. So non-fatal offenses against the person deal with the infliction of unlawful harm on the person. We already established that. The harm may range from serious injury to mental harm or to the near apprehension of harm or the simple violation of bodily autonomy. Now, there are 5 main non-fatal offenses listed in the graph, as you can see, in the order of their increasing severity. There's assault, also referred to as common assault. So either assault or common assault, they're both the same thing if you see it in the paper, either way. Okay. Then there's assault occasioning bodily harm, and then there is which is called battery as well, and then there is malicious wounding or inflicting grievous bodily harm, or wounding or causing grievous bodily harm with intent. All these things are listed in the order of severity. There's assault, there's battery, there's assault occasioning bodily harm, and then there's malicious wounding. And why are there 2 assaults here? Because we'll see later on that assault is usually, in assault you really don't have to touch. Okay, you really don't have to make connection or contact with the body, somebody's body. Okay. And we'll see how it has different variations. But the assault occasioning the bodily harm is a step over the assault, but it comes after battery. There's assault, apprehension, there is battery, there is touching, and then there is assault occasioning bodily harm. We'll see how it's different in the later slides. Okay. So now, like I said, that the sentence ranging from absolute discharge to a discretionary sentence of life imprisonment. So, I mean, in assault, you can either get a discharge, or you can get a little bit of fine, or maybe 6 months imprisonment or something like that. And then if you go over to battery, your sentence may go further up, a little more severe, and then more, and then more, and then more. And eventually, if you are causing somebody, wounding somebody, or causing grievous bodily harm with intent to harm them, you can even get a discretionary life sentence. And as we remember from murder, discretionary life sentence of life is that it's the discretion of the court, either judge or the jury, varies, whichever part you're in. They don't have to, they can sentence you to life. Okay, but the sentence of life would be the maximum. They cannot go beyond that. That's your discretionary life imprisonment sentence. Okay, there is another classification of non-fatal offenses. The way they are classified are the summary offenses, there are either way offenses, and there are indictable only offenses. Summary offenses are the offenses that like assault and battery. They are either way offenses, which means they can either be summary offenses depending on the facts, the situation, and they can only be they can also be indictable only offenses. Indictable only offenses have usually higher punishment, and they're more severe. So your assault occasioning bodily harm and malicious wounding or inflicting grievous bodily harm are the either way offenses. They can either go either way. Your indictable offenses would be wounding or causing grievous bodily harm. There is the maliciously administering a poison, etc., with intent to injure or annoy. Even annoying somebody can be an offense. Maliciously administering a poison, etc., so as to endanger life or inflict grievous bodily harm. We're not going to go in too much detail in the last two that I mentioned. Your guide has not in detail mentioned those, but I have put down in a graph for you, just so it's differentiable. If I will look at your, while I was reading there, I haven't seen any questions on that yet, but there may be some questions on it. If I find a question on these two topics, we can cover it and I will give you a detailed description of it. Other than that, these two are pretty self-explanatory and they are not as important because they're pretty straightforward. They're not, the examiner can only put so much twist on certain things. Okay. Next slide. What is assault? In the case of DPP versus Taylor, Divisional Court held that assault and battery are statutory offenses, despite the fact that their elements are defined under common law. So you should know that these offenses, they are called statutory because that's how they have been established. They do, however, have their definition, define their definition within the common law, and judges have described. And while you were through your reading, I'm sure you have realized that how many steps it took for them to come to the point where they have decided finally, okay, this is the definition now that we're going to use. And there is no guarantee that it's not going to change. It can obviously change. When maybe a new situation comes, and then they're going to add another point or edit another point or take one off. This is how common law works, as we all know. So anyways, they are defined under common law. However, in Haysted versus Chief Constable of Derbyshire, 2000, the case, it was 2000 case, the Divisional Court held that battery was a common law offense. Now, although these authorities conflict on this point, but the statute contains no definition of offenses which are defined under common law. Section 39 of Criminal Justice Act 1988 confirms that these are summary offenses. They are triable in the magistrate's court. There's another point for you to realize, to note down that summary offenses are the ones that are triable in the magistrate's court, the lower courts, and provide a maximum sentence. In Collins versus Wilcox, Judge Cobb stated that law draws distinction between assault and battery. Okay, and how they distinguish between these two, it's how they define the effect of the assault or battery on the victim. Okay, apprehension of immediate and unlawful personal violence. This should be your key phrase to define assault. Assault is basically apprehension. It's the apprehension. It doesn't matter if there's a little difference between U.S. and English law that defines assault, but they're pretty similar all over the place. Apprehension of immediate and lawful personal violence. The assessment of it, whether apprehension exists or not, is subjective. Victim. There's also that victim must apprehend immediate personal violence. This is one of the elements of the crime. So your access for assault would be causing another person to apprehend immediate and unlawful personal violence. Okay. Now consider these two with just this bit of knowledge. And you probably have read it. I have pointed some of these out for you on the slide. Pointing a knife in victim's face, it's an assault. Okay. Why is it an assault? It's just pointing a knife. He's not saying anything. He's not doing anything. Why do you think it should be an assault? Just looking at the definition, that's what we have now. Yeah, what kind of apprehension is that? Fear. Okay, yeah, there's fear. Okay, if any of you is replying to my questions and is coming to me privately, please check your messages. I would really like you to do it as everyone option so everyone can see what you are, how are you replying, okay? We all can benefit from it. Yeah, correct. Pointing a knife in victim's face. Of course, he's afraid. He doesn't have to be afraid, but even if he's not afraid, well, okay, what if he's not afraid? What if he's not afraid? Then you're just pointing at me. You're not going to hit me with it, or you're not going to poke me with it. Yeah, there is a subjective assessment. Still, of course, it is an assault. Yes. Okay, now look at it. Raising a fist to the back of victim's head. He's raising a fist. He can hit him with the fist anytime. Why does it not matter? That's correct. He cannot see it. It's behind him. He doesn't know if whether assault has been committed on him or her or not. You don't unless he has eyes on his back. Okay? Yeah. Correct. Good. Now that was taken from a real case, the third one. Opening a drawer to show victim a gun. Opening a drawer to show victim a gun. Hey, good look, I have a gun. She asks, well, is it loaded? He says, yeah, it's loaded, and I know how to use it. And after that, I'm going to kidnap you. And if you don't come with me, I'm going to shoot you. Is that an assault? Yes. Yes, it's an assault. Yes. It's very clear. It was a very simple, clear-cut one. Now, shouting at victim, I hit you, if the police weren't over the road. Why not? Why is it not assault? He told him that. Okay, Sandeep says yes. Sammy says no assault. Because of if? Sammy, you are getting there, but you are not approaching it from the angle where you should have. Police has nothing to do with it. I'm just going to give you that clue. Police have nothing to do with it. Think about it. Sandeep, why do you say yes? Yes, it should be a no. Okay, if you read the first part of the sentence, he said, I'd hit you. He didn't say, I'm gonna hit you. It's a proposition. It's an assumption that I would have hit you, but he's not saying that. I mean, I'm not gonna. If somebody is saying that to me, I'm like, okay. He didn't say he's gonna hit me. He would have, but that didn't happen. It's an assertion. It's an assumption. I mean, it's a scenario. It's sort of like a hypothetical. There is no threat there. There is no threat there. He didn't say he's gonna. He didn't say he will. He didn't say he is now. Okay? Yeah. He's just describing a situation that if it was not had happened, I would have hit you. But I would have hit you is not necessarily I am going to hit you. If is not going to cause fear, because when you read about assault, the elements are immediate threat of violence. If and buts are not, they take those things out of immediacy. Okay, they only make them hypothetical. Law does not run on hypotheticals. Well, they do, because we create examples and we try to make it to understand. But lawmakers do not take ifs and buts into consideration while making the law. If that was the case, then everything would have been an offense. That if this would not have happened, people say that out all the time, that if I was there, I would have punched him in the face. It's not an assault. You're not there, and you're not telling the person that you're going to punch him in the face. It's not an assault. Okay? So if you have a fact pattern where somebody is saying something like that, there is no immediacy. Okay? Doesn't matter how afraid that person is, but and he's thanking God and knows for how long, however many long, that if police wasn't here, I probably would have gotten punched. No, doesn't count as an assault. Okay? Maybe it can be taken as a passive threat, but passive threat is not assault. Now, okay, last one. Threatening to push the victim. A martial arts expert. He can kick his tail anytime he wants. A little guy, you know, threatening to push him. I'm going to push you, and there's a huge black belt guy standing right next to him, in front of him. Would that be assault? Okay. No. Sandeep says no. Anybody else? Okay. We'll see in the later. Now there is immediacy. He says, "I'm going to push you now," and the martial expert just standing there waiting for him to push him. There is immediacy. Okay. Okay. We'll look at it in a minute. There is a one element that it's like a sub-element that law describes it as it were, and this is a good example for it. Okay, now hold that thought, Andre. No immediate but not fear. Hold that thought, okay? And keep it in mind. We're going to talk about it. Assault can be committed in a variety of ways, such as by raising an arm, as if to strike someone, by pointing a knife at victim, by shouting threats of violence at a person, by sending a threatening text message or letter, making threats over the phone, or even by making silent phone calls to victim. Those are your actual cases. These examples have been cases from your taken from your actual cases. Remember Ireland, the case of Ireland? We read about it. These things are assault. They constitute assault. Court said that it does. Now, what is apprehension? Apprehension is the expectation. If there is no expectation, no apprehension, there is no assault. For assault, no physical contact necessary. Okay? Threatening words. Threatening words. Can they be assault? Yeah, they can be assault. It varies from case to case. Your case, one of your cases describes that. Now, Andre, when I said hold that thought, this is what I meant. Fear is not necessary to constitute assault. You do not have to be afraid to apprehend assault. Only the fact that I think this person is going to hit me now, immediate, it's a apprehension of immediate violence, okay? Not fear. Fear is not necessary, because that expert, that martial art expert, I don't believe he's going to be afraid, unless somebody is pointing a gun at his head, maybe, yeah. But it's still an assault. He's expecting the other person, this little guy in front of him who's telling him that I'm going to push you now, big guy. There is an expectation. He's expecting him to push him, but he is not afraid. He most certainly is not afraid. Okay? In order to certify the physical element of the assault, the victim must perceive the conduct and or words which cause the apprehension of immediate and unlawful personal violence. Expectation, not fear. Not violence. There doesn't have to be a violence, okay? If you say violence, not fear, no, you're missing an element. Apprehension and not fear is the differentiator here. Expectation is there. Fear does not have to be there, okay? There may or may not be violence, but violence does not really conclude that whether it's an offense or not. Okay, good, correct. What about threatening words? Like I said, are they sufficient to cause assault? Threatening words are not sufficient, they said. Like I said, case-to-case basis, right? Let's see it. Victim must have heard the threat and apprehended immediate personal violence. There was a case in the United States where a person called the victim and telling him that I'm going to come out there right now and I'm going to punch you in the face. Okay? Open the door. If the victim thinks that he is standing right there in front of my door, if I'm going to open the door, he's going to hit me, that's your violence. Victim must have heard the threat and apprehend immediate personal violence. It depends if he has apprehended the threat or not, if he's expecting an immediate violence or not. Okay? And like we said, fear, although it is not often present, fear is not necessary requirement of an assault. It is enough that the victim anticipated the use of personal violence, even if they were not actually afraid. For example, I have committed the accessories of assault if I threaten to push a martial art expert or a heavyweight boxer. If he thinks that I might strike him, even though he's not afraid of me. And indeed, he laughed at me, oh, come on, come at me, bro, or something like that. You're going to touch me? Go on and touch me and see what happens. That he's not afraid, but still a violence. Now it says violence must be unlawful. You would think that all violence would be lawful. All touching to somebody else's body would be lawful. All contact would be lawful. Unlawful, right? No, there are certain things that are lawful. For example, chastisement. It's the verbal punishment or the castigation for the children. When you're trying to discipline your children a little bit, law says within the limits. Every state, every country has their own laws about it, that how much you can, and that's fine. Self-defense is okay. Consent. What about consent? Well, consent, I kept consent to discuss at the last. It's fairly simple, but this just there are a few things to for you to see. For example, in sports, if you are from English common law country, you must have seen rugby. I think rugby is a pretty violent game. In America, United States, or American football, I consider it a pretty violent game for my taste. They're big, huge people. They're running after one ball, and they, at some point, if you have seen football, they all just climb on one person and push him to the ground. I would consider that violence. And if you break your nose, if you break your arm, if you break something in that, yeah, you have given your consent for that sport. But we'll see that, it depends on the severity of the crime or the action. Okay, now another one is self-defense, the big one, the huge one. Self-defense, the defense. You must have read in the defense. Now, self-defense is not just a defense for your own self. It's also a defense of somebody, your child, somebody who is next to you. You think that he's gonna probably get hurt, and you want to save him. Yeah, that's self-defense too. So that violence would not be unlawful. It's lawful. Lawful arrest. In the United States, if somebody, if the police ask you to, that you can help them capture an offender. It's called a lawful arrest, although a civilian is doing it. If that kind of situation is there, then it's lawful. And obviously, if a police is arresting somebody, that's always, well, it's considered lawful, okay? Lord Stein stated that words as well as silence can amount to assault. Remember we said whether only the words of threatening words can be assault or not. Lord Stein stated that they can be. But for silence, it depends upon the fact, because when a silent caller calls he intends to cause fear, and it is for the victim to understood that there is fear. Ireland, you need to look at the cases of Ireland and Burstow, 1998, for assault by silence and words. Immediacy is, what is immediacy? If it's not future, if it's not immediate right now, it's not an assault. If it's sometime in the future, I'm going to hit you 1 week from now. That's not immediate violence. No assault. Okay? I'm going to come in next time I'm in the United States and I'm going to punch you in the face. Not immediate. Can happen anytime. Okay? What is immediate? That's not in future. It's there now. Positive act, not a mission. There's an exception. There was one case where you must remember that a person kind of ran over a police officer's foot. While he did that, he stopped the car while the wheel of the car were still on the police officer's feet. Okay? He did not move it back. The defense in that case was regarding assault that it wasn't a mission. Okay? It wasn't a mission. It was not a positive act. The positive act was to run over, but the omission, they said that when they did not move, that was an assault. Running over wasn't battery. When they did not move, that was an assault. But the judge said that no, that was not an omission. It was a continuing act. If the act is already in continuation and you, don't do something that can make it better, that is not an omission, and you can get away with that, with assault. It will consider an assault. Okay, it is not an omission. It's the continuation of the act. Is not an omission, and hence it's assault. Okay, the mens rea of assault, immediate and personal violence, and these states of mind have attributed to the accessories of assault. Okay. Spratt held that subjective standard of recklessness is applied to non-fatal offenses against a person, and the House of Lords confirmed this decision in Savage and Parmenter in 1992. It's fairly simple, very easy. You know, what is in your mind. You have intended to cause somebody, put somebody in fear, and it is adding to the accessories of assault the actions that we just read, and that constitutes your mens rea of assault. All right, now battery. Intentionally or recklessly inflicting unlawful force on another person. It came from Collins versus Wilcox in 1984. Okay, force is what is the difference between assault and battery? It's the force. Assault is the apprehension. In battery, no apprehension is required, but the touching is. Slight degree of force even will suffice. You don't have to be hurt or harmed by it. Okay. Then battery also calls for positive act, not omission. Then in contrast with continuation of an existing act, not omission. That case was Fagan versus MPC 1958. That I just described to you a little while ago. Now, for example, spitting on somebody is battery. Cutting somebody's hair, battery. Punching, even kissing without consent can amount to battery. What is battery then? It's a contact with somebody else's body. The contact is unlawful. The force is applied. Okay? Now, what is exception here? Lawful force. We just read what lawful force is. Unlawful, same as assault. The exceptions are there. The self-defense, the disciplining of the kid, the lawful arrest. These are all the exceptions, and they are not considered unlawful. Okay? The exception is, again, like I said, law of force, then the defense of consent. Implied consent is mentioned in Collins versus Wilcox, 1984. So, consequently, physical contact of everyday life is not sufficient to amount to battery. Okay, we're riding in a bus. The bus stop, make a sudden stop, and you kind of bump into somebody else. That's not battery. Okay, only touching which goes beyond generally acceptable standards of conduct is subject to punishment. There was a case. Now, what about direct or indirect application of force? The direct force is I push you, okay? I punch you in the face, and my body to your body. Indirect application of battery would be then when you have something else between the two bodies where they make contact, okay? There is, for example, I grab a bar and hit you with it, okay? I turn the water on in my yard, sprinklers, and they just go into somebody else's yard, and my neighbor is all soaked. That's battery. I'm not touching directly his body. I just open the sprinkler system in my lawn, and I intend that it's going to go into neighbor's yard. He's mowing the lawn, and he's going to get all soaked. That's battery. But the intention is there, okay? It is sufficient to have direct physical contact with the victim through a medium controlled by his actions. You have a case here on point. It's called Haystead versus Chief Constable of Derbyshire, 2000. We already talked about it a little bit. There is another one. There's DPP versus K. Here the defendant is a minor. And it's a case in 1990. What he did was he wanted to do an experiment with sulfuric acid, and he took the bottle of sulfuric acid to the bathroom, and he wanted to see what can it do to the toilet paper. While he was doing his own business, he heard footsteps, and he grabbed the bottle and hit it in the hand dryer, you know, and left. So another student came later, and he wanted to dry his hand. As soon as he turned the dryer on, the sulfuric acid, because of the pressure of the dryer, which was hit in the dryer, it just kind of burst out, and it blown into his face, and it burned his face. Divisional court held in that case that it was battery, although the other kid, he did not squeeze the sulfuric acid out himself and put it on somebody else's face, but it still was battery. He wasn't even there. Defendant wasn't even there anymore. He had left long time ago. He just put his sulfuric acid in the dryer and he left. Similarly, in Thomas, 1985, when defendant touched and rubbed the bottom of a girl's skirt, Court of Appeal held that when you touch a person's clothes when he's wearing what he's or she's wearing, it is equivalent to touching as if you're touching his body, touching him or her. That's battery. Now, what happened in Haystead, if you haven't read it, it's a little bit, just very short description of facts. A woman was repeatedly punched by a defendant when she was holding a 12-month-old baby. And what happened is he punched her so hard that she lost control, and he dropped the baby out of her arms, and he fell on the ground and hit his head as a result of repeated punches. Divisional court held that the contact was with the medium and was sufficient to constitute battery. And although he didn't touch the baby, defendant did not touch the baby with his own hand. He touched the mother. He punched the mother. But the court held that here the mother of the baby, the child, was the medium, and it was sufficient that the child got directly suffered as a result of defendant touching the medium. The mens rea is intention or recklessness. Again, as we read before, subjective standard of recklessness applies here. Defendant must have intended or foreseen the actual infliction of force, not just the victim's apprehension of force. Like we mentioned before, it's not just the apprehension, it's the actual infliction of force. Okay. Next slide. Next, we have occasional assault occasioning actual bodily harm. It's a statutory offense. Harm is required. There should be some harm. It holds a maximum sentence of 5-year imprisonment. It is one up, like I said, from the battery or assault. Now, the actus reus that we read of the battery or assault is required to prove not both, it's either or, and it should coincide with the mens rea of either of them as well. And that actus reus should be a causation, should cause in resulting actual bodily harm to the victim. Like we read in the earlier lectures during causation, that the chain of causation can be broken where the victim's actions are not reasonably foreseeable. Remember that case where a person was kidnapping the woman and she resisted and she opened the door of the moving car and to try to escape. The court in that case had said that it was reasonably foreseeable that she was going to try to resist and escape. So any actions that are not like that, that are not reasonably foreseeable, would break the chain of causation. So you see that slightly bit of a difference here. Actus reus or mens rea of the battery or assault that's required to be proved, and harm is required. You have to prove the harm as well, and that would be your assault occasioning actual bodily harm. What is an actual bodily harm now? It's widely interpreted, includes any hurt or of injury calculated to interfere with the health or comfort. That Judge Linsky in Miller 1954 said that it includes any hurt or injury calculated to interfere with the health or comfort. If you think about it, the health or comfort, it can be anything from a little bit to a huge thing. Also, any physical or psychiatric injury need not be permanent. It doesn't have to be permanent, but any physical psychiatric injury, but not trivial or mere emotions such as fear, distress, or panic. Unlike assault, although fear is not necessary in assault, mere fear, although it's necessary, but mere fear is not going to make the case. Distress or even panic is not going to do it. Those just said that those were trivial. So it has to be a proper physical and psychiatric injury. How do you know it's going to be something that is non-trivial? Well, if it's prescribed, something is prescribed by the doctor. If you go to the doctor and doctor say, yeah, okay, you have some psychiatric problem, or this is a proper injury that you need medication for, or that you need a treatment for, that would be your non-trivial injury. Okay. The case in point is Chan Cook 1994, and it was confirmed by the House of Lords in Ireland and Burstow 1998. Temporary loss of consciousness was sufficient to amount to actual bodily harm. You passed out for a little bit. That is actual bodily harm. Okay, that's not trivial, that you passed out. The case in point is T versus DPP 2003. In one of the cases, a woman's ponytail was cut. That is actual bodily harm, although hair is technically a dead issue. But if you're going to cut somebody's hair as part of your body, it's considered an injury. And that was held in DPP versus Smith in 2006. What's the mens rea? Mens rea of assault or battery result in actual bodily harm. That is the intention or recklessness as to causing the victim to apprehend immediate unlawful violence, or intention or recklessness as to the infliction of unlawful force that would make your mens rea. No additional mens rea required in relation to actual bodily harm, and no requirement to prove that defendant intended to cause some actual bodily harm or was reckless as to whether such harm was caused. If you remember recklessness, we read about reasonably foreseeable, and the defendant would have seen that even if he knew that a result is going to occur, and even then he was reckless enough to take that action anyways, and hence resulting in that actual harm that he was anticipating by his actions. So none of that. It says law says no requirement to prove that defendant intended to cause some actual bodily harm or was reckless as to whether such harm would cause. But nonetheless, there is some harm. Okay. Next is malicious wounding or inflicting grievous bodily harm. Statutory is a statutory offense. It carries maximum punishment of 5-year imprisonment. The accessory AR is accessory unlawfully wounding or inflicting grievous bodily harms to another person. There are two ways, wounding or inflicting bodily harm. It's either wounding or either inflicting. Okay? Let's see what wounding is here. Broken collarbone, but not skin breakage. Is that a wound? No, it's not a wound. Okay. That was the case in point was Wood and McMahon in 1830. And Smith, it was held that cut inside the mouth was sufficient. They said that the skin, for the wounding, the skin has to be broken. Okay? The skin, how is the skin has to be broken? That not just the slight scratch is not sufficient. Whole skin has to be broken. If you remember from your childhood science class, the skin has two layers. There's the dermis and there's epidermis and there's the dermis. And then comes your flesh. So if a wound constitutes the breakage of the skin, it has to be both layers. The 2 layers scratch is not a wound. There's some breakage required, which also means that maybe a little bit of bleeding would be there too. Bruise is not wounding. Bruising. You punch me in the face and I have a big bruised black eye. That's not wounding. That's bruising. The case on point was for the bruises C, which is a minor, versus Eisenhower in 1984. That held that bruise is not wounding. Another one is that you don't have to have a wound on any external part of your body. Your inside of your body, for example, like I said, there's a case, Smith, 1837, which held that cut inside the mouth was sufficient. Why? Because the inside of the mouth is also your skin, okay? And if it breaks, although it's very thin and delicate, if it breaks, it's a wound. In Waltham, 1894, a rupture to the lining membrane of the urethra amounted to be a wound too. Okay? That is also a wound. So it's not just a part of the body that you see, it's the parts that you don't really see. Also, if there's a wound there, it's wounding. There's a lot of development in describing inflection. It says that the grievous bodily harm should be given its ordinary and neutral and natural meaning in DPP versus in 1961. Okay, inflection. They said instead of going into back and forth into discussions, you just keep it natural and simple. Grievous means serious. Doesn't have to be really serious. In one case, they have decided that it has to be really serious. But later on, Court of Appeals in Saunders, 1985, they said they took the really out and they said it just has to be serious. There is no gravity upon gravity is required. Infliction can be either by the way of assault, for example, some form of direct attack, or by doing something intentionally that may not itself be a direct application of force to the body of the victim, but does directly result in force being applied violently to the body of the victim, so that he suffers grievous bodily harm. May not be a direct application, but in resulting, simply put, it does result in grievous bodily harm, and that would be your infliction. So wounding is really your breaking. Thank you, Andre. Yeah, I am not big on science, so I don't know how many layers my skin has, but really what they described it as That's just not the top layer. Anything beyond the top layer needed to be broken. If you have just a little scratch where your the top layer is affected, that's not going to be wound. It has to go beyond your top layer. Now, I don't know how many layers of skin we have inside of our mouth or inside of our eyelid, okay, or whether there is a skin there or not. I really am not sure, really. But if you break that layer, it seems like there's only one layer, then it's abrasive. So as long as it goes beyond. Okay, thank you, and thanks for that information. I did not know that I had 7 layers of skin on my body. Great to know. Yeah, so like I said, there are 2 ways of doing it, and one is either assault and either by inflicting bodily harm, even though you are not applying direct force, but it still, even in the indirect manner, it still causes some bodily harm. What is the mens rea? Mens rea here is maliciously. Maliciously, what is malicious? It's intentional or reckless. Okay? Subjective test of recklessness is applied, like most of the times. And what is the degree of harm? Defendant must intend to or be reckless as to causing some harm. It doesn't, courts are reluctant to describe the degree of harm because the reason is because everybody has a different threshold of pain. Everybody has a different, amount of force that they can possibly apply, considering how big, small, strong, or they are. In Court of Appeal, Mowat 1967 it was confirmed by House of Lords that degree of harm defining is not necessary. Just harm. Next is your wounding or causing grievous bodily harm with intent. The actus reus and mens rea both. We have already discussed the case, the clause versus inflection in previous section, so we're not going to go into much detail now. And just remember that when we discuss in murder, the intent for grievous bodily harm is similar here. It's a statutory offense carrying maximum sentence of life imprisonment. Your actus reus is unlawful wounding or causing grievous bodily harm to a person. Difference or caused, Section 18, with inflict, Section 20. That's your difference. House of Lords has held that these words are interchangeable, and it was applied in Ireland and Burstall in 1998. If you read your Section 18 and Section 20, you will see that difference. What is mens rea here? The mens rea here is the intention to cause grievous bodily harm or to resist arrest or to prevent the lawful apprehension or detainer of a person. That's what your section says, and that's exactly how it is applied. Specific intent offense and mere recklessness is not sufficient. Direct intent in relation to causing grievous bodily harm if it is his aim or purpose to do so, or maybe oblique. That's where murder memory should come about. We read oblique intent in murder, where grievous bodily harm was virtually certain to occur, and the defendant appreciated this. The case in point was Medrick, 1986, and Wooling. Okay, we are almost at the end of the lecture. What is consent? It's a justificatory defense, as it provides in your course. It negates actus reus. Obviously, it's a defense, so it's going to negate your actus reus. The general rule is that consent only defense of assault and battery, not to any injury amount to actual bodily harm. Okay, there are exceptions, of course. Actual bodily harm and grievous bodily harm include injuries sustained during properly conducted sport, lawful chastisement or correction, reasonable surgical interference with and dangerous exhibitions. If you think about wrestling or boxing, all these kind of games, why do you think people just get up in the ring and let somebody else punch them over and over again repeatedly until they're just down on the ground and they cannot get up anymore? That's consent. They have them sign the release form and the consent form. Pardon me. Also, acts of body modification. Fix my nose, make it small, make it big, make my lips smaller, bigger, cut my eyes from here, make them bigger. These are all, you have a consent when you go under knife. There is no assault or battery there. Cosmetic surgery, like I said, ritual circumcision is often consented. It's considered consented. Body piercing, tattooing, you have your ears pierced, you have your eyebrow pierced, it is causing pain, it is causing some harm to your body, considering subjectively, but it is not battery or assault or wounding or malicious wounding or somebody's on somebody's person. Tattooing, it hurts. I've never gotten a tattoo, but I know how it hurts. They pierce your body with a needle, put a little hole in it, fill it with color. It hurts. I've heard it hurts. So yeah, it's a either wound or it's an inflection of bodily harm, but it's consented and it's okay. It's not an offense, tattooing somebody's body. Validity. Validity is important in consent, that about how you can give consent, but it may not be valid. Why? Because consent can only be given freely by fully informed and competent adults. If you are incompetent to give consent, if you are incompetent to make a contract, you cannot give consent. Okay? Consent obtained from a minor, obtained by fraud, as to the fraud of identity or of defendant, or to the nature and quantity of the act, is invalid. You're going to lie to me that you are a police and you're here to arrest me, and you apply force. No consent. If I go with you, that I haven't given you consent because I thought you were a police. Okay. Nature and quality of the act, where the fraud exists. Now, I am giving you. I'm going to give you, for example, facial or some kind of spa treatment, but actually it's not. You just put a poison in some mud mask and put it on my face and burn my face. Yeah, I didn't give you consent to do that. Okay, so validity can become an issue. All right, the chart I talked about, I have divided it into different headings. There's the offense, which are assault, battery, assault occasioning AVH, wounding, inflicting GBH, wounding or causing GBH with intent. They have the sources of law, where they come from. Then you have your actus reus, and then you have your respective mens rea of all the offenses. It's right there in front of you. It just brings it down. I did not add any sentence to it, but when I'm going to give you that graph, I will add another column to it and add sentence to it, so you have a complete graph. And I will post it online for you, so you don't have to, quickly write it down or something. We are 8 minutes over class time, but I started late, so it's okay. Now, I think I'm done. I don't have anything else. If you have any questions, please feel free to write it down. I'm here for a little bit, but it's better if you go down, go out to the Facebook group and please post your questions there. Do post questions there. I cannot urge you enough. I have to also show you one more thing. I have it here. There is a question and answer criminal law book. If you do not have it, buy it. As the examinations are coming closer, please buy it and start reading through it. The topic you read, and go in and find a question for that, and look up the answers. Make an outline and read the answer. Okay, it's very good. There's question answer. There's multiple topics discussed there. When I give you a mock exam, I take questions from here, but I kind of mix and match it. I don't really exactly give you one question or the other. I give you maybe take a part from here and part from there, and then I add my model answer, also respectively taken out from here. The format is from here because that's the format that we're going to follow for your exams in LCS. There, okay. It's written by Norman Braith. In the edition I have is 2011, 2012. There may be a newer one. Look for a newer one if there is any, and read through it. It's very helpful. It's very helpful for exam writing technique. It's very helpful for model answers. It's very helpful to see how you can spot an issue and how you can treat, how you can, you know, attend to it, and how you lay out your answer. It's very important for exam technique, and it's a good book. Also, there's a website where I take some of my notes. I do add my own in there. So if you, I will post it online. I will also post the name of the book there. And when we are going into the revision, we're going to do a lot of mock exams. I will prepare some objective questions, and just for you to really know what the law is on point. And we'll start doing that soon. And you will find notes that I prepared for you for defense and for this topic that we discussed today. And I'll post it online for you. So expect a lot of things, a lot of notes, and a lot of announcements coming from me online. And be active. I know we all have lives. You all are working. You all have probably families. Just come out and look at the forum at least once a day. Maybe there is something posted there. And my offer for defense is still open. Think about what you want to discuss, and think about what you want to, you know, put more effort in and put more time in to discuss, and we'll talk about it definitely. I'm going to sign out from here. I'm still here for a little bit, but I'm going to turn my camera off. And if you have any questions, please go on and write it down and send me an email, send me a message, post it on Facebook, and I will attend to it promptly.